Honorable family, friends, and community members and township members.
So are you going to be done soon?
I'm still speaking. Attempted to kill me.
Oh, don't even try that.
As a victim,
let's mute him because you can talk away all you want. Did I finish the name? Darius Johnson.
Brian Bowling on behalf of Mr. Johnson in case ending in 1734, Your Honor.
Yes, Your Honor. Brandon Bird on behalf of Darius Johnson and in the case ending in 5312. Mr. Johnson, state your full name for the record.
Darius Johnson.
Judge, we're asking that, my matter and speaking for Mr. Bird, his matter gets set for preliminary examination. I believe discovery to be completed in my case.
Correct, Your Honor. Both matters set for exam, please.
You understand we have a violation?
We do understand it's a violation. At first, we thought it was a progress report, not technically a violation, Your Honor.
Because it said progress report at the top of a violation. It says violation.
But Your Honor, respectfully, it is a lot going on with my client. He had a medical marijuana card.
Does he have one?
He doesn't. He doesn't have.
I just got to renew it.
So you don't have one.
Expired. So I technically don't have one.
He doesn't have a medical marijuana. He doesn't have a medical marijuana card.
That's either you do or don't.
I don't.
You don't. Okay.
It expired in 2023. But my client does suffer from PTSD, Your Honor. He went to prison at a young age, at 18 years old. He did 5 years in prison. Self-medicating. It's self-medicating off of that right now. He is taking care of his little brother. His little brother is his dependent that depends on him. Has one child. He has built a successful life for himself with a successful clothing line, but still times is difficult, Your Honor. Taking care of his little brother, taking care of his 3-month son. Went out of town to see his son because he needed to.
Can I chime in? I just got it's no excuse for me not having it. I just got it. Like, you just give me the opportunity to get it, I can have it like tomorrow.
You can have what?
Tomorrow, I can just go online and get it.
And he did come up here. He knew it was going to be a chance.
He was supposed to community corrections told him to discontinue use until he had that medical marijuana card was received and it was approved by the court. But you didn't do that.
No, I didn't.
And that was back in January that they told you that. And you still continued to use. All discovery is complete.
In my case, yes, Judge.
In my case, as far as I know, yes, Your Honor.
People, other witnesses available to 17. Preliminary examination in this matter will be set February 17, 2026, 9 a.m. before Judge Moore. At this point, you can't follow instructions and have you out. Bonds revoked. Defendant demanded.
This is the moment the defense's mitigation strategy collapses into a compliance problem. Counsel offers PTSD, family responsibilities, a business, and an expired medical marijuana card to explain the continued use. Those facts may humanize Johnson, but they do not answer the judge's decisive question: was there a valid card, and did he obey the January instruction to stop using until court approval? Johnson's own answers remove the ambiguity. The card expired in 2023, he admits he does not currently have one, and he continued using after being expressly told to discontinue. His claim that he can obtain a renewal tomorrow may actually hurt more than help because it confirms the authorization was missing when the violation occurred. Did you notice how Judge Simpson repeatedly reduces the issue to a simple yes or no question? That signals the court is testing reliability, not debating marijuana policy. The preliminary examination will address whether the prosecution can establish probable cause on the charges. Bond compliance is a separate question. By revoking bond, The judge is saying that release depends on following current conditions, not promising future compliance after being caught.
Gardner.
Your Honor, we are asking for an adjournment to review the discovery, and I'm hoping to make a bond argument as well.
Man, I lost my screen. Seeking an adjournment as well.
Please, Your Honor.
I will adjourn the matter to the 19th. Probable cause conference will be adjourned February 19th. 2026, 9 a.m. Master bond.
Judge, Mr. Gardner submits that he can be saved community if given a PR bond. He reports to me that he was doing really well before he was arrested. He was working for a program that enabled him to work in exchange for housing, and it was going well. He believes that he can get back in if he's released. He's unable to get back in. He does have a place to stay with his sister, who lives locally in Washtenaw County. He will seek other work. He is motivated to resolve this, Your Honor, and he promises to attend all court dates and follow through with all bond conditions.
Your Honor, we believe that where bond is currently set as appropriate. This is a situation where, as I recall, we may have been staying at a hotel, and through the course of this, did threaten to kill or someone, right? To have them kill the officers who were involved and/or their families. We believe this gentleman is
He threatened to kill the officers in his family. Oh.
He is also just really dangerous to the public.
Anything else?
No, I leave it at.
I'm going to deny the motion for bond reduction. Bond will remain. Right. Thank you.
Your Honor.
Here, the defense presents the classic release package: prior stability, employment tied to housing, a local sister, a place to stay, motivation, and promises to attend court. Those points are designed to address flight risk and show that community supervision could work. But the prosecution answers with a far more serious public safety allegation: that Gardner threatened to kill the officers involved or have someone kill them and their families. On a bond reduction motion, the judge is not deciding guilt beyond a reasonable doubt. The immediate question is whether the existing bond remains necessary to manage non-appearance and danger while the case is pending. That distinction matters because credible threat allegations can outweigh generalized assurances, especially when the defense offers promises but no concrete supervision plan, verified placement, or other safeguard in this excerpt. Would a promise to follow conditions reassure you after an alleged threat aimed at officers and their families? Judge Simpson's ruling is extremely brief, but the brevity itself shows the balance was not close. The defense's favorable background did not neutralize the prosecution's safety concern. Bond remains unchanged, preserving the status quo while counsel reviews discovery and prepares any stronger argument.
Case People versus the cases of the People versus Dara Akiji.
An Assistant Public Defender Jay Bellinger on behalf of Mr. Ikeji on all cases not ending in 1678.
Good morning, Your Honor. Jonathan Sachs for Mr. Ikeji in case ending in 1670.
Your Honor, our client is present via Zoom from the jail.
Yes, sir. If you can state your name, please.
Greetings, honorable family, friends, and community members and township members. My name is Chidera Bennett DKG, and I'm entering into my rights to plead the Federal Fifth Amendment, bonding me into the right to remain silent for the rest of the trial. One of the only reasons the prosecuting party will proceed to provide lacking evidence is because they want me to forget the root cause of every case or pretension presented against me today. Last reason I'm providing you with is I'm prepared to stand in on the fact that I do not want my mother or my father provided with a stroke or heart attack, recognizing the county of Washtenaw, city of Ann Arbor, all within the same.
So are you going to be done soon?
I'm still speaking. Attempted to kill me.
Don't even try that.
As a victim,
Let's mute him because you can talk away all you want. What are we doing on this?
Your Honor, may we approach, please?
Well, sure. Go on up.
Yes, he was done.
Okay, record should reflect we had bench conference in this case. The defendant has stood up, but is still present in the room. We've received competency reports indicating that the defendant is competent. Do we have any other additional evidence for the court to consider?
We don't, Your Honor. And as I stated at the bench, I understand that a new competency request was signed by this court, and then we got the report back right after. So we would be stipulating to competence on all of the files, despite the fact that there's still that outstanding competency order.
All right.
Your Honor, the people would stipulate have no further evidence as the court find defendant correct.
Same, Your Honor.
The defendant is competent to stand trial in this matter. I will sign the competency orders. I will then set a probable cause conference in this case. I will set a probable cause conference for March 5th.
Yep. Okay. Thank you very much.
2026, 9 a.m. Bond will continue.
Mr. Akeji, I will visit you. Thank you, Judge.
Thank
See
you.
next time.
All right. Thank you, sir.
Take care. Good to see you.
Wow. Let's copy that. The only difference in that one is wow.
The final dispute turns on competency, separating unusual courtroom rhetoric from legal incapacity. Ketty invokes the Fifth Amendment, refers to executing parties, and attempts to deliver a broader statement, but unconventional language alone does not establish incompetence. The key question is whether he can understand the proceedings and meaningfully assist counsel. Here, competency reports find him competent, both sides stipulate, and neither side offers contrary evidence. That is why Judge Simpson signs the orders and moves the files to a probable cause conference on March 5th. The judge's decision to mute the defendant is procedural, not a ruling that his constitutional rights disappeared. A defendant may invoke the right against compelled self-incrimination, but that does not give him control over the hearing or prevent counsel and the court from addressing competency and scheduling. Did his speech raise concerns worth examining? Certainly, and the reports show that examination occurred. But would the speech alone overcome professional evaluations with no competing evidence? On this record, no. Across this docket, the same principle controls every ruling. Courts evaluate present compliance and risk, not future promises. Johnson's expired card did not excuse continued use after an instruction to stop. Gardner's release assurances did not outweigh the alleged threats, and Ketty's rhetoric did not displace the competency evidence. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.